Good afternoon, and thank you for joining us on our High Volume Consumer Claims webinar. It marks the launch of the Solicitors Regulation Authority's discussion paper on that subject. So a really warm welcome to everyone, whether you're joining us live or watching this as a recording on demand. My name's Richard Silver. I'm a Policy Associate at the SRA, and I'll be chairing the webinar. So just to briefly set the scene before we get going. So over the next hour, we'll be discussing and taking your questions as well on high volume consumer claims. So in particular, we're going to be discussing the discussion paper and providing you with some walkthrough of that we launched last month, and also looking at 5 key challenges that are within the paper and that we're seeking views on actually. So in terms of the format for today, we're going to begin shortly with a presentation, and before we'll move on to some questions and answers as well after that. So to submit a question to us as we're going along, as part of the live broadcast, that is, you should be able to see a link directly beneath this video, and you can simply type your questions there as they come to mind. So please don't be shy. By all means, do start submitting those questions as they come to you, and we'll try and put as many of those across to our presenters towards the end of the webinar. So without further ado, we'll get started actually with the presentation. So I'm delighted to be joined by 2 colleagues who are going to be talking us through that today. Harriet Gamper is the SRA's Director of Consumer Policy and Engagement, and we'll hear shortly from Harriet. But firstly, I'm going to hand you over to Aileen Armstrong, the SRA's Executive Director for Strategy, Innovation and External Affairs, to give you a bit of a background to the paper. Okay, thanks, Aileen.
Thank you, Richard. Before we get into the real detail of what we want to talk about today and the discussion paper that we've put out, I'm just going to take a couple of minutes for a very quick recap and to kind of situate us correctly in, what we're talking about in terms of what is a high volume consumer claim. And so when we're talking about high volume consumer claims, we are thinking about those claims that arise when large numbers of consumers file claims against the same organisation or in relation to the same issue. Examples of that are, you can see many of them, and we've got them listed there in terms of housing disrepair, data breaches, flight delays, diesel car emissions, motor finance commission, and other financial services. So those are types of claims that all have, key factors in common. And the first thing to say is that when high volume consumer claims work well, they provide affordable, or they can provide an affordable way for people to enforce their rights, making it, a really important route for consumers to gain access to justice. Equal pay claims, for example, are a good example here. But we have seen too many firms failing in their duty to protect and promote clients' best interests when pursuing these claims. And that, of course, impacts on the trust and confidence that consumers have in legal services. And so this really is a key area for us at the SRA. So why are we so concerned? We think there's clear evidence that the market is not operating as it should, and we think this is directly causing significant harm and detriment to consumers. We've put up there on the slide, we currently have live investigations into 76 firms operating in this space. And between them, these firms handle hundreds of thousands of claims. So we're really wanting to understand more about what's happening here. And so we recently undertook a thematic review to look specifically at day-to-day practices within firms working in this area. And this review drew upon, we kicked off the review by doing a survey of 129 law firms active in the high volume consumer claims market. And those 129 law firms were altogether handling more than 2.4 million live claims. So that was, a big survey to look across a number of firms. And from that survey, we then identified and we then took it forward and conducted in-depth visits to 25 of those firms. And we used those visits to interview staff and we analysed client files. And, what we have to say here is the findings, were concerning. Although there were some areas of good practice, we did find worrying levels of non-compliance or poor practice. So, just to explain in terms of those 25 firms that we visited, in fact, of the 25, we are currently investigating 9 of those firms. So that, indicates to us that there are issues that may not be, one-off in individual firms. So I also wanted to just highlight some of the issues we found through the work of the thematic review, just to pick off kind of 5 key areas. We were identifying failures to fully consider clients' best interests regarding litigation funding and referral arrangements. Second, we found clients not being given the required information about costs and the options available to them. We also found instances of poor compliance with regulatory obligations when arranging after the event insurance, often referred to as ATE insurance for clients. Fourthly, again, evidence of weak systems in terms of checking how referrers are acquiring and onboarding claimants. And the final one that I would pick out is that we did see evidence of inadequate advice to clients about their the merits of their claims and the prospects of their claims success. And so clearly, all these issues obviously have the potential to be breaches of our rules. And, what is underpinning that then is also if they're breaching our rules and there are these problematic practices, these are things that are going to directly cause harm to consumers. And the findings of the review also are kind of aligning and echoing what we are seeing through other areas of our work, including, the investigations that we have ongoing. So I just want to speak briefly about what we're doing about this, because obviously this has highlighted a number of areas. So, what action are we taking? So, as I've said, this is a very high priority area for us. And we do have those ongoing investigations. Those are really important, and we will, see those through. And if we need to investigate other firms, of course we will. But while we are conducting those investigations, and as people will know, investigations need to be done diligently, and although we will move, and we are moving at pace, these things do take time. So while we are have that ongoing, we have also stepped up our action to both provide help and support to the profession and the public, but also to ensure that we're being proactive in other areas to identify areas of poor practice and to intervene as needed. And again, this is because, you know, with the evidence of this being, you know, a widespread issue, we need to do all we can alongside those investigations to address, you know, this area of potential consumer harm. So those things that we are doing, you know, include setting up a new proactive investigations team, which enables us not just to respond to reports that are coming through the door, but, you know, gives us the functionality to be able to go out proactively and look into areas where our data and insights and evidence suggest that there may be concerns, and to be able to really understand that which we don't know yet. So it allows us to be more proactive. And those listening to this conversation now who work in the high volume consumer claims sector will also, I imagine, be aware of another step we have taken, which is an ongoing mandatory declaration exercise that we are running. And what we have done here is we have written out to law firms operating in this space. Over 700 firms have received letters from us requiring them to confirm not only that they understand and are following our rules in this area, information about how they are doing this. And as I said, this is a mandatory exercise, so completing the declaration is mandatory. And if in completing this declaration, a firm identifies that there are areas that they need to improve their practices in terms of how they operate, etc., then we are also putting those firms on notice and requiring them to ensure that they take any immediate action that's necessary to remedy anything that they uncover that really isn't as it should be. And we'll of course be reviewing all the responses to the declaration, and we can and we will take action as necessary if we find that firms are not complying with our rules. Now, of course, our preference here is to help firms to do the right thing in the first place, to make sure that issues don't arise, and if there is something to sort it out quickly and effectively. And we're also interested and have a role in helping the public understand what to expect and what questions they should be asking when contemplating using a law firm here. Excuse me. Now, we've already published a range of guidance and warning notices to firms on key compliance issues. And last year, in addition to that guidance for firms, we published a public guide, for consumers, potential consumers of these services. And that guide was about showing people kind of red flags and questions to ask before signing up to a no-win, no-fee deal. And so we're going to continue to work with partners and other agencies to address new and emerging issues, and we'll provide further guidance on these as appropriate. So to take an example, there's a lot of work that we are doing with partners, other regulators and wider, but a good example is when the FCA recently announced that it would be consulting on a redress scheme for consumers involved in motor finance claims. We issued detailed guidance advising firms that they must understand what's happening here and explain the implications of that to their clients. And the focus there is really, to make sure that firms are focusing on advising their clients in their best interests about how to proceed. we've also issued information to the public, advising them to ask their firms to explain and, explain to them in plain English what that ruling means, and to consider if they wait for what happens next before engaging in further work attracting costs. So a real onus on law firms looking at what is in their clients' best interests and advising, given the changing landscape around them, advising accordingly. Another example that we've been involved in relates to housing disrepair issues with the imminent introduction of RWAB's law, which is likely to lead to an increase, we think, in housing disrepair claims being made. And so ahead of this, we have taken the step to remind all law firms of our rules and best practice principles for handling such cases. And in particular, we've been bringing to solicitors and firms' attention our warning notice on how they market their services and how they onboard potential claimants. And then outside of these examples, more generally, as we talk to law firms and consider themes emerging from our wider work, we're continuing to consider how we can provide wider guidance and support materials. So, for example, we're currently considering further guidance covering topics linked to issues such as litigation funding, where clients, where there's a danger of clients unwittingly signing up to multiple referrers, and a more general warning notice picking up the recurring themes from our investigations and thematic review. So where we are spotting issues, say, around litigation funding, or where clients appear to not know that they've been signed up, and then it presents as there being multiple people handling the same claim, and just issues more generally, we will do our bit in terms of issuing further guidance and trying to bring clarity. And lastly, we are of course aware that this isn't an area where we alone can address all of the issues. So as I've already kind of highlighted, we've worked jointly with FCA on motor claims, or the Ministry of Housing and others on RWAB's law, that we're actively engaging with agencies and bodies across multiple sectors, and engaging with areas of government, and want to speak to as wide a group of stakeholders as we can. And that's why a conversation like today is really valuable. And so that's really a snapshot of our wider ongoing work. But many of the issues and challenges in the sector potentially require longer term thinking and change. And that's really the context in which that we published our discussion paper on the subject recently. And on that, and to talk us through a bit more of the issues that we've highlighted there, I'm going to hand over to Harriet now. Thank you.
Thanks, Aileen. My name's Harriet Gamper, and I'm Director of Consumer Policy and Engagement here at the SRA. So thank you for joining the discussion today. As you can see, I'm going to run through the call for input that we have launched just last month on those 5 key challenges. So the paper identifies 5 ways where we think the sector could be operating slightly differently, and we're inviting views from a wide range of people. So the areas that we're looking at are around how we could improve transparency and clarity for consumers about their claim, how the risks around third-party litigation funding could be better managed, how to make sure after the event insurance is meeting consumer needs, how regulation can keep pace with a changing market, and how we might deliver wider improvements, so across the system, for consumers in the high volume claims process. So I'm going to sort of talk to each of these challenges in a bit more detail. But just to notice and to sort of really pick up on what Aileen was saying earlier, many of these questions are not for us or even for the legal sector on its own. You know, they do require also actions and input from others. So we are working with a very wide range of stakeholders to look for solutions. So in terms of challenge 1, clarity and transparency. Aileen mentioned the thematic review and the investigations work that we've been doing, and we have been seeing a lack of transparency and clarity for consumers. And that is particularly at the point where they are considering whether to sign up to a claim. So consumers can become aware that they've got a potential claim through marketing and advertising. And of course, that can be a really good thing. But we want each consumer to be well informed about how a firm will help them to pursue their individual claim. So often claims are marketed as no win, no fee. And we are concerned that sometimes this term doesn't give people a view of the risks and potential costs that they might have to pay if a claim is unsuccessful. We're also concerned that the term doesn't give people with some other issues, like instances where it's not clear to consumers that they've entered into a contract with a firm. And we've received reports that some consumers have found themselves being unexpectedly represented by more than one firm for a single claim. I think the other issue to pick up in this area is around taking account of each client's individual needs and circumstances, and that's particularly important when clients are being onboarded. So we wouldn't want to see firms taking a one-size-fits-all approach. We recognise that some consumers can be at greater risk of harm because their individual circumstances can increase their vulnerability. And this is something that can be true of anybody, but it can also appear more frequently in certain areas. So housing disrepair could be one of those. So we are also carrying out direct research with consumers who have used solicitors' firms to make claims. And one of the particular objectives of this research is to identify if there are any impacts on those who might be at greater risk of vulnerability. We want all consumers to make informed decisions about the services they need, to understand how their matter will be handled, and to know what options are available to them. So, under this first challenge, we're asking some quite big picture questions. And this includes whether the term no win, no fee should be used, how it can be made clearer what consumers are signing up to, and making sure that they're aware of any risks that are involved. And we're looking at whether there's anything we can learn or indeed avoid, so looking at comparisons with other sectors. As I said as well, we're also interested in ways that firms can avoid a one-size-fits-all approach. Moving on to challenge 2. This is all about managing the risks around third-party litigation funding. So the third-party litigation funding market, as I'm sure you will all be very well aware, has grown a lot in the last decade, and it's not currently subject to compulsory regulation. The Civil Justice Council has recommended it should be, and we are very supportive of that. We also recognise that it can help clients who might not otherwise be able to fund their legal action. But for the benefits to emerge, it's really important that the right standards are being met. So our thematic review that Aileen mentioned earlier found that 23% of the surveyed firms working in high volume claims use litigation funding, and that totaled around 200 million. So it is very large. And because of the way that funding can be structured, we're concerned that sometimes firms' incentives might not align with those of clients. So for example, there may be an incentive to take on as many claims as possible even when pursuing a claim might not be in an individual client's best interests. A firm's interest in their relationship with the funder can also conflict with the interests of their clients in some cases. For example, because the funder might want to influence how or whether cases progress. And finally, the thematic review also identified some firms who had taken on very high levels of funding relative to their annual turnover. So our concern in this area is that this could lead to financial instability if a particular type of claim was to fail or fall away. So that could obviously create issues. So we're looking at all sorts of options, and that's alongside the recommendations of the CJC. And that includes issuing advice to firms on litigation funding that will come out later in the year, and also using the data from our mandatory declaration exercise, which Aileen talked about earlier, so that we can identify and act on any concerns around financial instability. We're also considering changes that we might need to make to our regulations, and that could include things like routinely collecting enhanced information of the sort that we're doing at the moment to make sure that consumers are adequately protected. We know that there's a need to work with others in this area, and so we're very keen to hear about the sorts of information that consumers need and would find useful about funding agreements, and how to make sure it's clear and it's provided at the right time. We also are interested in areas where firms might manage, or have good practices around how firms can manage litigation funding risks. So moving on to challenge 3. The next couple of issues relate to quite specific, but absolutely no less important issues. So first of all, after the event insurance and making sure that that meets consumers' needs. So ATE insurance is widely used, and it is a product that really benefits consumers because it can provide protection against costs in the event of an unsuccessful claim. But of course, it only works when firms fulfill their obligations under the policy. So this is an area that spans different stakeholders and regulatory regimes. And when we're thinking about improvements, we would want those to lead to greater consistency in how products are used by firms, which obviously leads to ultimately to improvements for consumers. So in its review of litigation funding, which I mentioned earlier, the CJC also recommended that ATE insurance policies could include robust anti-avoidance clauses. These are clauses that can be used by defendants in group litigation orders, and they can help to reduce the risk of a dispute about the cover that's provided in the event of an unsuccessful claim. So this is an area that we're looking at to see if it could reduce the risk that a consumer might end up being left to cover the costs unexpectedly. So some of the questions that we're asking in this area is around what we could do and also what could be done by others. In terms of challenge 4, we're also concerned that poor compliance with our standards and regulations is leading to consumer harm, and we're thinking about whether we need to make changes to our regulatory approach to manage some of the risks that we're seeing. So with that in mind, we're seeking views on areas like if and how we might enhance our regulation of firms working in this area. So for instance, should we have an enhanced authorization process, and or should we continue our program of proactive checking of compliance of firms already working in this area? And finally, as we've said, not every issue is within our remit to resolve. So consumers, as you will all know, can pursue claims across a very broad range of areas across the economy and through a variety of different routes. So there can be specific redress schemes, there might be ombudsmen, there are different regulatory frameworks, and of course also the courts. And there are different regulators in some of these areas, so the landscape is quite fragmented. So we're looking at how we share intelligence between ourselves, so between legal and other regulators, and how we use wider regulatory frameworks to protect consumers. We also see an opportunity to learn from good practices in different areas. So, for example, we think there may be good practices to be found in the use of group litigation orders and some parallels that we might draw with that area. And we believe there is scope for the consumer interest to be better protected by the wider system. So we're asking, what more could we do here, and what more could others do? So that is quite a sort of brief and quick walk through the discussion paper, but that's left us with plenty of time for questions. So I'm going to hand back to Richard to take us through some of those.
Thanks so much for that, Harriet. Yes, you're right. Plenty of food for thought there, and certainly some, as you say, some big picture areas actually that we're really keen to hear views on. And actually, that's a nice way to move us through to the this second half actually of the webinar today. We're going to pose some questions actually to the presenters, if that's okay. So big thanks to everybody who's already sent us some questions in. Quick reminder actually before we get into that section that if you haven't yet done so, but you've got something on your mind, or even if as we go along, you know, there are thoughts sort of coming to mind as we go through, then please do continue to use the link that you'll see below the video if you're watching live, and we'll try and get through as many as we can in the time that we've got remaining today. So we'll kick straight off then, if that's okay. So we've had a question in here. I'll just read it out as we've received it. So the discussion paper appears to question the very concept of law firms working on a no-win, no-fee basis. This is an approach used far wider than just in law firms. So is it realistic to suggest the SRA may dictate changes in this area? So actually, if I could ask Harriet, if you've got any views on that question firstly.
Yes, thanks, Richard, and thank you for the question as well. So obviously there's a range of ideas and questions which are outlined in the discussion paper. And some of these are there to stimulate thoughts and opinions. So we're not consulting on policy proposals at the moment, but we're at an earlier stage in the process. And so we want to hear a really wide range of views. Our strong view is that really more does need to be done to protect consumers in this area. And we do think that looking at the term no win, no fee is something that needs to be done. So we want to hear views on those solutions or potential solutions, and as well some of the areas where, you know, people think that that might not work. We're very interested in any evidence as well that anyone can provide, sort of quantitative or qualitative, as part of the discussion paper and the engagement period.
Will I come in there as well, Richard? Just to make the wider point, I agree with everything Harriet said, and particularly, you know, that question was on no win, no fee and the use of that term. I just wanted to make the wider point as well and encourage people. You know, we've launched this discussion paper, and we want it to be a discussion ongoing through to November about issues. So on that issue and wider things, you know, what we are doing here is seeking wider views, seeking insight, seeking understanding of how things are working in practice, and you know, really wanting to generate ideas, alternative approaches, etc. So you know, everything that Harriet said, I think this is an area, the specific area that we do need to look at, but there will be views, and we really do want to have the discussion, open that discussion, and make sure that we are hearing from as wide a set of perspectives as possible.
That's great. Thanks both for that. Yeah, so absolutely. If that's sparked anything in anyone's minds in terms of views that you would like to formally send back through to the discussion paper as well, as a response around no win, no fee terminology, then that's absolutely a great mechanism to use to get information to us on that in terms of your views. So we've had another question here. Again, I'll just read that out for you. So a recurring challenge appears to be the relationship and responsibilities of referrers versus law firms in sourcing clients. what is the SRA's expectation regarding how a firm assures itself that those passing on referrals have followed due process? So yeah, Harriet, what do you think about that one?
Thanks, Richard. And I'm sure Aileen will have some reflections on this as well. But I would start by saying firms are accountable for making sure that all their clients have given consent and had everything fully explained to them. So that is really, really important. And of course, how a law firm chooses to do that is their responsibility. And there are different ways to do that. But it is really important, I think, to have a process in place that gives you assurance that all your clients have been recruited in a way that complies with our rules. And I think the other thing that's really important is that you're able to show evidence if you're asked that that's what you're doing. So yeah, I think really accountability does rest with the law firm for its processes. And yes, we would want to be able to see that if we asked.
Yeah, I would just reiterate that final part. I didn't know, Harry, if you wanted me to come in, but I think it is really reiterating that point. If people are feeling confused or law firms are feeling confused, I think that the clear message is that the accountability does rest with the law firm. To ensure that anyone making that you're taking those referrals from, is doing so in a way that is in line with the duties. So I think that's the underpinning point.
That's great. Thanks both. Really helpful. So we're getting some good numbers of questions in, so we'll carry straight on into the next one if that's okay. So we've got a question which relates to, I think, one of the challenges around the funding of litigation elements of claims. And so, yeah, we've been asked here, the discussion paper raises questions about how litigation work is funded. Is it in the SRA's remit to have a view on how we financially manage the business side of our firm? So yeah, either of you, please feel free to pick that one up.
Will I pick that one up? I think a law firm is best placed to decide how it runs its business, but of course, I think the wider picture here is that in order to make sure that consumers are protected, we do have requirements in place around monitoring the financial stability of firms. So, it's a requirement on firms to make sure that you do have an effective mechanism in place to monitor your financial stability. And I think the reason why I'm highlighting that point here is that, in the recent thematic review and wider work, we do see examples and evidence of cases where firms were entering into litigation funding without necessarily conducting kind of checks on making sure that the arrangements that they're entering into don't compromise the firm's financial stability. So examples that we've seen in terms of firms not having a contingency or a kind of financial backup, about how they would repay funders that they've taken on an arrangement with if the claims failed. And we're of course concerned that if firms don't have and haven't taken the necessary precautions to protect their financial stability, that then if there's an increase in failures for that reason, and there isn't the planning there, and it can lead to hurried, disorganized exits from the market, that can have severe consequences for clients. And that's not good for clients at all. It's not good for access to justice. It's not good for the reputation of law firms in this space. And given the the really high volumes of clients we can be talking about here in terms of what is on any one firm's books, the impact of that is potentially vast. So I think it is absolutely right that the regulator, that we SRA focus on those areas of risk, and I think that's why there is the existing obligation on firms to make sure that they are looking after their financial stability, and to tell us if there's a problem or a potential problem there. And I think the discussion document and this conversation is also about saying, well, are there other things that it would be right for us to do? Are there other things, in terms of our authorization or other things, what should we be doing? We want to get into that conversation.
Great, thanks so much, Aileen. We've had a question coming in terms of the types of groups and the people that we're, I guess, interested in talking to. And it's really around lenders and insurers in particular, and actually whether we're going to be consulting or whether we already are consulting with those types of stakeholders actually, and those kinds of sectors. So I'll direct that one to Harriet. Is that okay?
Yes, that's fine. Thanks, Richard. And yeah, it's a good question. So yes, in terms of lenders and insurers, we are talking to them, and also to a really wide range of other people as well. So obviously other regulators we've mentioned, but obviously also ombudsman schemes, consumer organisations, and there are sort of lots of other people as well. So for example, surveyors are another group who might be providing expertise. So as well as this webinar, we've got a number of round tables which are taking place. So some of those are on areas like insurance, for example, and we will also carry on with our programme of smaller one-to-one meetings as well across the discussion period. So all of that, and I should say as well, really encourage you to respond to the discussion paper, but of course from these roundtables and all the other engagements that we're having, we're feeding all of that information in as well.
Great, thanks, Harriet. So sounds like plenty of opportunities actually for people to get involved, and certainly we're more than happy to hear views from any interested parties there on some of these big ticket issues. Okay, that's great. Thanks so much. So another question we've got here: do we accept that there are occasions, even when a free scheme is available, when going through a firm can sometimes be preferable? So I guess that's in terms of whether there might be situations where we think that it is viable for a member of the public to think about using a firm in those kinds of circumstances, even where there are free routes to redress. Yeah, I'll ask Aileen if you'd like to have a look at that one.
Yeah, I'm happy if Harriet wants to say anything as well. But I mean, I think actually, I think Harriet had already touched on some of this in terms of the real need for firms to be really clear in their dealings with clients. So even where there are cases where a firm believes they have a client signed up already, in the case where then a free scheme becomes available, we think it's important that firms are really clear with their clients about what is available, what options they have. And I think this also relates to being really, really clear that upfront for clients about the consequences of choosing one route or another, the sort of costs involved, even if there's some uncertainty, having that kind of plain English, real clarity about what the choices are, and where it is going to be in clients' best interest. It has to be open and clear for clients. Actually, if a free scheme is going to be better for them, they have to be free to make that choice, and that should be open to them, and we want law firms to ensure that they're being really transparent and clear and explaining to clients and in all of their communications just more widely. So, you know, even if someone isn't a client at the moment, in putting out information in a space where there are, you know, other options available and being really clear, you know, that those are options open to consumers, I think is really important. And again, I think all of this is underpinned by the obligations that, you know, all law firms and solicitors are and should be familiar with in terms of, you know, making sure that, you know, you are thinking of your clients first and foremost and giving advice in their best interest.
Great, thanks so much, Aileen. So we've still got a few minutes left, so we'll dive straight into another. So we've been asked here, could the focus on this area drive up costs to consumers and or insurance costs for firms who are working in this space? So yeah, any views that we might have about that one? Harriet?
Yeah, sure. Thanks, Richard. So it's a good question. I think that we have gone through the examples and evidence that we have been seeing of harm and detriment being caused to consumers in terms of poor practices in this sector. So for us, not taking action isn't an option. So I guess the really important thing to say here is that, of course, our regulated firms already have an obligation to make sure they comply with all the rules and regulations in this area. So really, I think what we're talking about is making sure that that's what's happening in practice. So we don't think that that would necessarily lead to increased costs for consumers. It's also about making sure that the playing field is level, though, as well. So making sure that people who do play by the rules aren't being disadvantaged by those who don't. So yes, I think, you know, we do see a clear need to take action here. Really, I think what we're seeing is making sure people play by the existing rules and that everybody who's in the area is playing by the rules in the same way.
Yeah, I do think it's a good question, and I agree with you, Harriet, that where, you know, a lot of what we've seen and the thematic review definitely brings this home. If you read it, a lot of that is about areas where we have clear rules at the moment, and what we think we have found is examples of, you know, and instances that raise concerns that those are not being followed. And just to be really clear, you know, in terms of the discussion paper, what we've tried to do is make sure that we're setting out the context of everything we're doing. And a huge part of that, as Harriet has just said, is then about, you know, the declaration exercise, the investigations that we are doing, getting warning notices and making sure that people understand their obligations. All of that is a real focus on making sure that firms are delivering against the obligations that they have. And so it was really important that in this discussion exercise, in this engagement that we're doing, that we're reiterating that, and that is, you know, very much part of what we are doing in this space. And then on top of that, there are some issues that, you know, deal with different sectors beyond legal services. Someone in the question that we just had talking about insurers and others. There are these wider areas, as well as a question of whether we are doing everything in our rules at the moment that we should do in this space, given the concerns we've highlighted. So on things that could lead to, you know, a change going forward, then of course we would consult on any changes. We would be looking at ensuring we have an obligation to ensure that our regulation is proportionate, and so it's about looking at if there were something more and additional needed, what would be a proportionate and appropriate response to that to address the harm that we identify. So I think it is that distinction, but I think Harriet's main point is absolutely the right one. There is a lot of things that we have highlighted here, which the thematic review highlighted, which is about compliance with the current rules.
Wonderful. Thanks, Aileen. And actually, I mean, I think that does feed through nicely in terms of all of these issues that we've been exploring today. And we've touched slightly on some of the different groups that we've already been engaging with and plan to. But I've got a final question, if that's okay for you, Aileen, in terms of the messages that we like to give to people who are watching the webinar. So how can anybody who's watching this live with us or watching it on demand get involved in this process with us, get their views heard, and actually have their say?
Yeah, thank you, Richard. And the thing I want to kind of say here is, thank you for your time and attention and questions today. That is really appreciated. We're doing this, and the document is available because we want to have this conversation and to get more input. So we really value and appreciate your time. So because of the importance of drawing in views during the period of the discussion paper exercise, we are going to be continuing to reach out. This is one kind of early event. There's going to be many more events that we are organising to engage directly with stakeholders, including consumers, including the profession, including some of the wider stakeholders that people have already mentioned. So we will have roundtables, and I wanted to highlight that there's a couple of events coming up that may be of interest to those on this call. We've got virtual roundtable events for the legal profession to discuss the issues raised and to give us feedback on the discussion paper. There's going to be a focus in those roundtable events for the profession on challenges 1 and 4, which are about the challenge about transparency and clarity for consumers and improving that if necessary, and how we regulate in a changing market. And so, as I say, several events going on during the period up to 14th of November. But on those two roundtables, they're not trying to tackle different things. We're just running two so that people have an opportunity to sign up and take part. So we'll, in effect, be running and asking the same questions, but obviously the conversation will be will reflect the people who take part. But we're running that event on 2 different dates. So please do have a look at that and pick the one that's most convenient to you. The first one is on 7th of October, and that's between 12:45 and 2 o'clock. And we've got a second one on the 6th of November. So the dates are on the slide there. The one on the 6th of November is in the afternoon between 3:15 and 4:30. So if you'd like to be involved in those, please do sign up through the events page on our website or from the links that are in the discussion paper. And we've referred to it a lot. I should have just said up front that the discussion paper is there on our website for you to be able to respond to. We've put the links on this slide as well, and alongside other materials, including the recording that we'll put up of this video, you'll find links there to events, to the discussion paper, and further material on the subject. So please also do think about, if you follow up after this webinar today, we would also like to hear your feedback on this webinar. So you can also use use those links, and you'll find a way to give us feedback on that as well. Thank you very much, Richard.
Wonderful. Thanks, Aileen, and a big thanks to you both. Actually, we've had all sorts of information and things to think about there, so it's been really helpful. I think big thanks to everybody who's sent in questions as well today. If we didn't get around to your question, then do rest assured we are going to look through them all, and we'll see actually how we can cover them off potentially in some of those other events that Aileen just mentioned there, or some of our other communications as well. So we do really appreciate receiving them. Again, the resources that Aileen mentioned there in terms of links to the discussion paper, and also if you have a moment just to let us know any feedback you have about the webinar today, we'll be really grateful to receive those. And so all that remains for this webinar today is to say a big thank you again for joining us. I hope you enjoyed it, and goodbye.